How are out-of-state sex offenders designated when they move to New York? To find out, you have to read People versus Talluto. It's only 13 pages. Don't have time for that? I got you covered. This is the TLDR Court of Appeals episode on People versus Talluto, Talluto, which can be found at 2022 New York Slip Opinion 07025, published on December 13th, 2022. This is a criminal case. This is a case, it's an interesting case, where the issue here is whether or not the court has any authority or leeway to avoid implementing a law that everyone kind of feels is illogical and doesn't make sense given the fact pattern presented. And the answer from the Court of Appeals is if there's any reason that the legislature gives for the law, it has to be applied according to the plain language. I'm going to give you the facts of the case. The case is applying the Sex Offender Registration Act, which is found in Corrections Law 168. And the question here is, should a person who's convicted of a sex offense in another state be deemed a sexually violent offender? And the reason why it matters is if a person is a sexually violent offender, then they're going to be on the Sex Offense Registry Act registry for life. It's a lifetime placement on that list, on that registry. If they're not a sexually violent offender, then it's 20 years. So it's a big difference in the life of a convicted person for a sex offense, whether it's 20 years on the list or a lifetime on the list. And the way that the law was written, it says if a person was convicted in a foreign jurisdiction, and I don't mean India or China or England, foreign jurisdiction here, think New Jersey, think Michigan, think Wisconsin. If a person was convicted in a foreign state in the United States of a sex offense that would land them on their own sex offender registry, then if they move to New York and they get placed on the registry that way, they are automatically considered a sexually violent offender, a sexually violent offender. Now, in this particular case, the defendant was convicted in Michigan of an offense involving having sexual intercourse with a person between the ages of 13 and 16 related to that person. No violence is part of the statute. No violence is part of the conviction in Michigan. But they move to New York. The Board of Examiners is notified, and they wind up having a SORA hearing. The question is, how does the judge adjudicate them? Everyone, including the defendant, the people, the judge, even the Board of Examiners of sex offenders, who's the one that gives the recommendation of how to sentence one of these individuals who's convicted of these kinds of offenses, all say this person should not be a sexually violent offender. But the judge at the trial level feels compelled to adjudicate the person a sexually violent offender because the statute says if they come from another state where they have committed a crime, a conviction, that would land them on their own registry, when they come to New York, they are automatically a sexually violent offender. The judge feels compelled, sentences the defendant as a sexually violent offender. Defendant appeals. The appellate division agrees, says we also think this is illogical. But the judge was right. Defendant appeals, goes to the Court of Appeals. And here they go through a long, extensive conversation. And really the importance of this case is they reaffirm the preeminence, the importance of the legislature. The court's job is not to fix bad statutes. It's to apply the statutes that the legislature has drafted. That's what the Court of Appeals says. They say, well, our job is not to carry forward ridiculous laws that make no sense, but if there's any possible reason why the legislature may have made this kind of a law, we have no leeway to modify it. And so they go through the legislative history and they come up with a reason. They say, well, the reason why it was written this way may have been to save it to get federal funding. And they say, given that it's a clear and unambiguous law, there's no discretion, no leeway the judge has but to impose this statute, which everyone essentially agrees is probably a drafting error. That's the majority holding. Now, Judge Wilson has an interesting dissent. Judge Wilson reviews the same statute, agrees it's illogical, but Judge Wilson says that upon his reading of the statute, there is some discretion that the judge has about whether to, in fact, sentence the defendant as a sexually violent offender. This is not shared by the majority. The majority disagrees and says Judge Wilson's seeing things that aren't really in the statute. But that is the dissent by Judge Wilson. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.